Welcome to the Banco Court in Brisbane. My name's Peter Applegarth. Tonight I have the pleasure of wearing two hats, one on behalf of the Australian Academy of Law, the other on behalf of the Supreme Court Library Queensland and the Australian chapter of the Selden Society. I acknowledge the presence of the Chief Justice of Queensland, Justice Helen Boscawen, and thank the Chief Justice for permission to use the Banco Court. I also acknowledge the presence of my judicial colleagues present here or online, including the President of the Australian Academy of Law, the Honourable Alan Robertson, Senior Counsel, and the presence of many distinguished guests, jurists, present and retired, here or online. At a Selden Society lecture a few weeks ago, my colleague Justice Thomas Bradley remarked about the long history of people meeting in this place and acknowledged the traditional owners of the lands on which we gather, the Yagara and Turrbal people. I likewise acknowledge the traditional owners and custodians of this land. For a large part of my adult life, I thought Meanjum was just the name of a Melbourne-based literary journal founded by a Queenslander. It's kind of compulsory to mention Queenslander at these events. But that was my knowledge of Meanjum. Only very late in my life did I learn that Meanjum is the Turrbal name for the land on which central Brisbane is located. Laws governing trade have operated in this place for thousands of years, not just a few hundred. But that much shorter period is our focus tonight. Our distinguished speaker, Professor Sir Ross Cranston, Queen's Counsel, is an expert in the development of commercial law in England and Australia. Tonight he'll explain that the commercial law in the period that he has heavily researched and written about was empire law, but in the Australian context it sometimes took a different path from that in England. I should mention the Australian Academy of Law is a broadly based non-governmental body comprised of individuals from all parts of the legal community. Its fellows work together for the advancement of the discipline of law. The Academy seeks to promote the highest standards of legal scholarship, education, legal practice, and the administration of justice. The Selden Society, supported, as again tonight, by the Supreme Court Library, has a deep commitment to public education and the exploration of legal history. The Academy and the Selden Society could not have hoped for a speaker who better combines experience as a scholar and as a jurist than Professor Cranston. After graduating from the University of Queensland with university medals in history and political science and in law, Ross undertook postgraduate work at Harvard and Oxford. He's been the Castle Professor of Law at the London School of Economics, a leading scholar and author of major works on banking and finance law. As if that wasn't enough, he's been an MP, a Solicitor General for England and Wales, and a High Court Judge for England and Wales. Sir Ross still sits as a judge and has returned to being a professor at the London School of Economics. His recent book, Making Commercial Law Through Practice, 1830 to 1870, is a brilliant work which has been a major part of Ross's life with deep research into archives and sources. It explores how laws governing commerce, trade, manufacturing and finance services developed. In tonight's lecture, Making Law Through Practice, Examples from Commercial Law, Sir Ross will address the Australian dimension based on his archival work in Australia. Would you please welcome Sir Ross Cranston.
Well, first of all, let me acknowledge the traditional custodians of the land, as Peter has already done, the Turrbal and Jagera people and their elders past and present, and all Aboriginal and Torres Strait Islanders present here and online. My own links are recent, where my ancestors settled in the mid-19th century in Rockhampton, the traditional lands of the Durrumbul people. I acknowledge the impacts of, on these original occupants of empire and colonisation, which I'm going to talk about this evening. I want to thank Peter, Justice Applegarth. Well, last night he took me for fish and chips on the front at Sandgate.
Cheap date.
And he threw in a milkshake. I'm very grateful to him because he first suggested the lecture, and I said, keep it short in terms of the introduction. Well, he hasn't done that, but anyhow. I also have to thank the Academy of Law, its President, Alan Robertson, the Queensland branch of the Selden Society, and I want to thank the Chief Justice and the judges of the Supreme Court for facilitating the lecture. I want to thank in particular Justice Thomas Bradley, who's been helpful in the arrangements. And just finally, I want to thank Michael Boyce, Peter's associate. I can't see him, but I said he had to be close by in case anything went wrong. Well, the subject this evening is a very large one, and it draws on this recent study of Britain's international trade and manufacturing and the financing of these from about the first part of the 19th century until the 1960s, the beginning of the modern period, which actually may be coming to an end. But the period that I looked at was a period where Britain was the first industrial nation, an international power, with a huge international trade, with these attendant commodity, financial, insurance and shipping markets. And of course an extensive empire, all very much diminished by the First and certainly by the Second World War. I want to take three themes which I deal with in the book, only three of the themes: markets, sales and agency. And as Peter said, I'll take examples from Australia and from Australian archives. As I say in the book, these aspects of commercial law, these commodity markets and international trade and so on, they had a dark underbelly, and you can't get away from the circumstances of the role of slavery in the Liverpool cotton trade, the Chinese opium trade, the treatment of First Nations peoples and so on. But that's not for tonight. So let me begin here with the wool stores in Brisbane, now converted to luxury apartments with restaurants and cafes, and where Peter didn't take me last night.
You insisted on fish.
But this is the, you can't see it, but this is the old Goldsborough Mort and Company wool store. And Dalgety was there, and various other stock and station agents, as they were called. There was also, Dalgety also had a grain store in Tenerife, and just upstream was the CSR sugar refinery. I'll come back to that later on. And inserted in that slide is a description from a Privy Council opinion of the agency functions of these stock and station agents. So I'll come back to that. So the Tenerife wool stores, if I'd be permitted just one personal recollection, these were well known to my brother and me when we were children growing up, because our paternal grandparents lived in Beeston Street in Tenerife. Less posh than it no doubt is these days. But on our weekly visits, we would go down to the wharves. There was no security or little security, and we'd go along to the vessels that were moored there, and we'd call up any matchboxes, and the crew would throw down matchboxes for us, because my father was amongst other things, was a voluminist. Anyhow, let's start with these wool stores, and I want to talk about the international markets for the selling of Australia's wool and wheat in the Age of Empire. So wool's there in the wool stores, ready for export, much to Britain. Wheat as well. Wheat not so much produced in this state, not the Darling Downs, but the southern states, South Australia and West Australia, are the great producers. And from the 1890s, a real export trade in wheat. And wheat was very much valued on the international markets, the Australian wheat, because like the American wheat, it was of a consistent quality. And there was very little in the way of disruption, whereas with India, with Egyptian wheat and Indian wheat and so on, it was much less highly valued. Anyhow, the techniques for these two markets were different. With wool, it was by auction. Wheat was by standard form contract. There were wool auctions in London from the early 19th century. From 1875, it was at the Wool Exchange in Coleman Street, just around the corner from the London Guildhall. It was an international market prior to the First World War. About half the wool sold there was going to American and European buyers. On arrival, the wool was stored at warehouses near the docks in London. And here's an old photograph of the London docks and the wool in the London docks. And I should say that you, Peter, your predecessor, Chief Justice, they both had tours of the area. Linda Appel, the former Agent General in London, and Ron, they've had tours as well of the area. So I'm offering you a tour if you come to London, and others as well. A fascinating area. But as with other commodity auctions, catalogues were prepared for each sale. They briefly described the lot. They stated the dock or warehouse where it was stored, and prospective buyers would go down or would send their agents to inspect it. And you can see that in the very back of that photograph. They're inspecting the wool. From the late 19th century, wool-producing countries like Australia and New Zealand very cleverly and very sensibly assumed greater control. And you start to get auctions here in Brisbane, Sydney, Melbourne, and so on. And the volumes began to surpass the volumes sold in London. But as Miles Franklin records in her autobiographical novel, My Brilliant Career, published in 1901, the London wool market was still a focus of attention for Australian wool producers in setting world prices. Now, Britain had a long experience with auctions. They'd been used for selling land, for selling works of art. Pepys, in his diary, records observing the frenzied crying, in other words, bidding, for 2 ships in the middle years of the 19th century. That was auctioned by candle, as it was called, because you burned down the candle, and that was the end of the auction. The underlying legal principle was freedom of contract. Sellers and auctioneers could, by contract, exclude themselves from liability for the conduct of auctions and also the description and quality of the goods sold. And on the slide there, you can see a standard condition that the wool was to be taken away by the buyers at their own expense within 14 days with all faults and defects of whatever kind, including defect or error of description. So for the lawyers amongst you, you appreciate that they were excluding the common law principles of implied conditions which were codified in the Sale of Goods Act of quality and description. And that's why the brokers for the European, for the Yorkshire, for the American woolen mills had to come and look at the wool because they weren't going to be protected by any implied conditions in the sale. The English courts gave auctions a very wide berth. So did the Parliament. There was an Auctioneers Act of 1845, but and you had to pay an annual license fee of £10, but the identity of the collector of the license fee, the Commissioner for Customs and Excise, gave the game away. It was a revenue raising device, not an attempt to regulate trade. Now, as I say, the auctions were conducted on the basis of written conditions. Typically, they were spelt out in the catalogue. The courts very early had no difficulty in deciding that everyone was bound by those conditions, even though you weren't aware of them. The practice in the London markets was that goods went to the highest bidder, no surprises. What if there was uncertainty as to who was the highest bidder? The House of Lords Select Committee in 1856 asked that question. They asked it of someone called Sir John Holmes, who was a very prominent solicitor. In fact, the firm he was a member of became what is now Clifford Chance. And you'll see here a drawing of the London wool auction, and the description there accompanying it from 1884 is possibly why the lay observer or the House of Lords Committee might ask this question, because of the pandemonium. Let me just quote the newspaper about the auction that was observed. The auctioneer has to sell £100,000 worth of wool before 6 o'clock. Lot 213, 10 bales, he says. Simple words, but the signal for a tempest of excitement. It's a bear garden, a babel, a scene of indescribable confusion. And to the uninitiated spectator, it seems as if the frantic bidders were about to spring from their places and punch each other's head. But the auctioneer speaks one word, and the storm is still. That word is Tompkins. The lot has been knocked down to Tompkins. Without drawing breath, the selling broker goes on to the next lot. So the answer to the House of Lords question was the experienced auctioneers, in this case, had no problem in identifying and marking down the lot to Tompkins. Mr. Holmans, however, gave the belt and brace legal answer. He said, well, to avoid litigation, there should be a condition in there that if there was confusion about who was the highest bidder, the bidding should be recommenced, and that in fact was put in as a standard condition in some of the catalogues. So that's wool being marketed in London. Wheat, here the London markets handle huge imports of physical wheat for consumption in Britain and elsewhere in Europe. But they also provided transactions in wheat futures for hedging and speculation. And those derivative markets still continue to the present day, commodities futures. They've been joined by interest rate and other financial derivatives. And it's a huge derivative market in London, and so far not significantly affected by Brexit. But from the late 19th century, Australian wheat was sold internationally on the standard terms drawn up by what was called the London Corn Trade Association. They use the term corn, but it's not sweet corn. It was actually wheat, grain. In terms of the international trading occurred on the Baltic Exchange, and there's the very fine building built in the late 1880s, which the IRA blew up in 1992. Rather inconsiderately. But the Baltic Exchange had rules drawn up by its members to govern transactions in wheat and ships, which were traded there. And as you can see in the quotation, the deals were done by word of mouth, the contracts being completed subsequently. And there was the famous statement, "My word is my bond." The London Corn Trade Association, formed in 1878, it drew up many contracts. It's now GAFTA. It's still existing and drawing up international contracts for the sale of grain and for food trade. Its membership was drawn from a wide range of parties concerned with international the international grain trade, brokers, importers, shippers, millers. In its work, it was in close contact with other interests, shipping, insurance, and banking. Following its establishment, there was a profusion of trade associations with their own commodities, sugar, coffee, palm oil, and so on. And these markets set world prices. So there were the contracts for the transactions. Contract was also important in building institutions. I've mentioned the Baltic Exchange. There was also the London Produce Clearinghouse, when it was established in 1888 for clearing commodity futures. It's now the LCH Group, and it provides clearing services across many continents and multiple asset classes, commodities, swaps, derivatives, foreign exchange, and so on. And it clears over, quadrillions of dollars worth of products every year. So it started with wheat and then went on. Let me just make a few further points about, or three further points about markets. First of all, brokers were central to their operation. Brokers there on the Baltic Exchange, brokers there auctioneering the commodities when they were auctioned. They were little regulated, as I've said. Secondly, futures contracts, very important. They involved obligations to deliver or receive a standardized quantity, standardized quality and amount of a commodity at a specified price and time in the future. Actual delivery wasn't contemplated. The trades were settled by the payment of price differences. And very soon there were, let me see, here's a specific contract for grain futures in London. So they drew up specific contracts to govern futures dealings. And because everything was standardized apart from price, all you had to negotiate was price, and then you had your contract covering all the other terms. And the fungibility enabled dealing so that you could close out simply by paying by entering the offsetting transaction. And then the third point is that law had little to say about the emergence of the speculative dimensions, this speculative dimension to commodity markets. There was the gaming legislation meant you had to have a clause there that said you had to deliver, but no one contemplated delivery. So that's a little bit about markets. Let me turn to sale. Sale for commercial lawyers was always the central transaction. There's a discussion these days in the literature about the death of sale, the rise of hire purchase, asset finance, and so on. In the book, I demonstrate that these techniques were used in the 19th century. For railway wagons, for example, they were all financed by hire and hire purchase. And they became, of course, important for white goods, motor vehicles, aircraft, IT equipment, and so on. But I'm going to concentrate on sale. And the point is the parties could, and they did, write their own contracts with their own rules regulating matters such as where liability fell if things went wrong. As the genius behind the US Uniform Commercial Code, Carl Llewellyn, recognized many years ago, sales law would lie in the hands of the drafter, the negotiator, and the arbitrator. As I've said, the London Corn Trade Association had standard form contracts, and it had a number of contracts for, even in the early 20th century, it had a number of contracts for Australian wheat. Here's a 1913 contract for Australian wheat being sold in parcels. Parcels, of course, large tonnages of wheat. And there were standard form contracts for other Australian wheat as well, wheat to be shipped, shipments that had arrived, and so on. I apologise for the scissors and paste here. I'm a bit old-fashioned in terms of that slide. But there was a balancing of interests in the drawing up of these contracts, these standard form contracts, although it's fair to say that after the First World War, the balance changed in favour of shippers, in other words exporters, as economic power slipped away from Britain. So for present purposes, 6 short points, as counsel should say to the judge. Probably not 6, 3's enough. But 6 short points about these international standard form contracts. First, in broad terms, they codified mercantile practice, whether in the quality standard set for the commodity. You'll see here fair average quality of the season's shipment, or equal to the official standard of the London or Liverpool Trade Association. They standardised the manner in which, they codified the manner in which the commodity was to be shipped, insured and paid for. Secondly, there was, the drafting was a practical exercise. When you look at the archives, lawyers weren't really involved. It was the brokers themselves, the members of the Trade Association, who were doing all this drafting. As time went on with the arbitration clause in particular, that's not there, because there was an accretion of case law, lawyers started to become involved. But basically it was the trades people, the merchants, who drew up these contracts. Thirdly, because English law was permissive and facilitative and non-judgmental, the trade associations could vary the law, vary the common law principles, the sale of goods principles. So you'll see there, one of the clauses is above the shipped in good condition clause. The grain is not warranted free from defect, rendering the same unmerchantable, which would not be apparent on reasonable examination, any statute or rule of law to the contrary notwithstanding. So in other words, contracting out of merchantability, which was the standard set by the law. And the other example I've got there is in terms of remedies. With breach of a condition in a sale contract, you could reject. Not so. The clause provided, and it's the last clause there on the slide, differences in quality shall not entitle a buyer to reject, except if the arbitrators award that. The fourth point is that any harshness which this freedom of contract produced was not to be mitigated by equitable rules concerning matters such as unconscionability. I see Justice Derrington sitting in the front here, and the same applied in the shipping market. It didn't matter if the owner withdrew the ship to take advantage of a rising market because there's a late payment, a couple of days late. That's what the law said. But no unconscionability. Now, I can't, because I'm in Brisbane, I cannot but show a photograph of Lord Atkinson I've said Abu Dhabi there, it's actually in Welsh Aberdyfi, but there he is on the jetty. And he wouldn't have a bar of equities intervention. Just as well I'm giving this lecture in Brisbane rather than Sydney. But he made it quite clear there was a leading case, re-weight, which involved an international wheat transaction. And he said, no, we're not having any equitable principles muddying the commercial law, the common law. And there's a letter that he wrote to one of my predecessors as the Castle professor at the LSE, Professor Guttridge, in the 1930s, headed Business Against Chancery. In other words, Chancery equity is no good for business. But anyhow, the fifth point, I better move on, given the online audience. The fifth point is that when disputes about commodity sales arose, and couldn't be resolved by the parties. They were settled in the vast majority of cases by the trade itself. Arbitration, as I say, became the favoured method. But the interesting thing is it was arbitrated by tradespeople themselves. Lawyers were kept out. And that's still the rule with GAFTA, the International Grain Arbitration. No lawyers. On the whole, no lawyers. And it was what was called look-sniff arbitration. As we saw when you're looking at the wool, you just looked at it, and you knew what the quality was. And you very quickly made a decision as an arbitrator about whether it was up to quality or not. The sixth point is that if there were any untoward court decisions, as occasionally there were, they were overcome by redrafting the standard form contracts. So those are the soft commodities, wool and wheat, and there's a whole different area with the hard commodities like minerals and oil. But what about manufactured goods? I want to venture south now to Tasmania, and that state's purchase in the late 1940s of 18 steam locomotives for its railways. The tender for the engines was announced by the Tasmanian government on the 23rd of December 1948. For engine buffs amongst you, there may be some. 10 light 462 type locomotives of 20,000 pounds tractive effort, and 8 heavy 482 type locomotives of 28,000 pounds tractive effort for service on the, and this is old money of course, 3'6", same as in Queensland, gauge, in conformity, quote, with the specifications attached. Now, no tenders were received by Australian manufacturers, but there was interest in Britain, and the successful tenderer, the successful tender was from a company associated with Robert Stephenson Companies. In 1823, Robert Stephenson was the first steam locomotive manufacturer in the world, and by this time it had a large, in the 1940s, had a large export business. And here are some Robert Stephenson engines being exported. This is from the 1930s, not the Tasmanian engines, but being exported to India. So in the Tasmanian case, negotiations occurred. There were the Agent General for Tasmania was involved. Robert Stephenson had an agent in Australia who was involved, but mainly it was done between the Tasmanian government authorities and the manufacturers. One interesting feature was that it was only when the contracts were drawn up that they involved a lawyer, and a lawyer on the Tasmanian side. And he said the tender had not been made subject to the usual conditions that we require, namely the lodging of a security deposit and a penalty clause for late delivery. And unless you get the manufacturers to agree to a variation, those provisions won't apply. I mean, it's simple, of course, contract. It involves offer acceptance, as every law student knows. Well, it appears from the file that the Tasmanian authorities let the matter go and the manufacturers weren't approached, and fortunately all went well. There were minor disputes. There was some rusting. You can see that the engines here are on the deck, so you can understand in a long journey there's going to be some rusting, and that was dealt with by compromises in terms of price and so on. Incidentally, I understand for the engine buffs amongst you that from the tourist brochure, I think, that some of these engines still survive on the Don Valley Heritage Railway in North Tasmania. I haven't been there yet. But relevant to my theme is this, that these Tasmanian contracts were typical as regards the sale of plant and machinery. There were detailed contracts, there were extensive conditions, there were extensive drawings, The buyer might provide the specifications. In this case, it was mainly based on the seller's catalogue. And there was an additional assurance because the buyer, in this case the Tasmanian government, appointed a London engineer to go along and constantly inspect the work as it continued through the production process. Let me turn to my third topic, agency. Historically, I think you can say, or you can argue, as I do, that agency law was of equal importance to contract law as a legal device facilitating commercial activity. Occupying a range of different roles, agents were and are central to the functioning of commercial life. I've touched on brokers as agents. Let me give a few Australian examples, or examples relevant to Australia. I mentioned Dalgety and Goldsborough Mort, stock and stage agents. Here's a photograph from the 1930s, and you can see there Dalgety's as stock and station agents, but also underneath they're brokers, grain and produce brokers, and along the fascia on the side, which you can't read actually, they are auctioneers as well. So they're acting as agents in various ways. And you can see from this quotation from the High Court decision in 1916 that they also provided finance to farmers and graziers, and I'll come back to that. So then there were the agency houses. That term was used in various parts of the world to reflect how the trading firms bought and sold goods, sometimes on commission as agents, true agents, but sometimes as wholesalers, as well as providing other agency services such as shipping, insurance and banking. One mid-20th century account of British trade and China says the agency house, though primarily a trading house, also acted as bankers, bill brokers, ship owners, freighters, insurance agents, purveyors, and so on. Now, it may be that a firm, and the name will be familiar to many of you, Parbury Henty was one of these agency houses. The archives are available in Canberra, but I haven't been able to look at them. So I'm going to refer to Jardine Matheson. Its archives are in Cambridge, and I have looked at those archives. It's still going strong. It's a Fortune Global 500 company. It's thinly disguised in a novel, Taipan, which was written by an Australian-born novelist and screenwriter, James Clavell, a novel I think published in the 1950s or 60s. It acted as a managing agent, Jardine Matheson acted as a managing agent for mills, insurance companies and shipping lines. And here's it acting as an agent, as a managing agent for the Indochina Steam Navigation Company Limited. As you'll see, serving Japan, Hong Kong, Australia, Tasmania. Obviously, whoever designed this didn't realise Tasmania was part of Australia, but and then New Zealand. So they were managing agents, actually managing the business. Another example of agency was when agents weren't really agents in the legal sense, but they adopted the name agent. The High Court of Australia had confronted this issue in 1958 when pastoralists bought an International Harvester automatic pickup model number 50T hay bale. The brothers who were running the pastoral company had seen this at the Sydney show. Here, of course, they'd see it at the Brisbane Echo. And they were told, and actually I'm grateful for Michael for getting an accurate photograph of that from YouTube. But the brothers thought, well, this is what we want, to bale our hay. But they were told, well, you have to go to Kensel's in Gunnedah. They're our agents, quote agents, they're our exclusive agents in the area. So they went there, they bought the baler from Kensel's. The baler didn't bale. So they complained, didn't get any satisfaction. Kensel's by now is insolvent, so they sue International Harvester. The full court, and they do that on the basis that Kensel's were the agent bringing them into contractual relations with International Harvester. The full court of the New South Wales Supreme Court bought the argument over the dissent of Miss Justice Owen, but in a joint judgment the High Court would have none of it. They allowed the appeal. As the court said, quote, no one supposes that the, quote, distributing agent or, quote, exclusive agent in a particular, quote, territory for a commodity or specified kind of article or machine is there to put a, quote, consumer into contractual relations with the manufacturer, end of quote. In other words, although Kensel's were described by as International Harvester's exclusive agents, they were not agents in law. So agency in practice didn't always fit the neat categories of the law. But of course, terminological inexactitude was good marketing. You could claim to be the agent of this international company, and of course, petrol stations and car dealers and so on. They are Ford agents, they are Shell agents, and so on. And that leads to modern franchising, that same sort of approach. A point I've already made, of course, and I'm repeating, is that the true agent in law could perform many functions. They might be agents, true agents, but they might also be doing other things as well. And as I said earlier, and we saw that on the slide, Dalgetty's as providing finance as well as providing agency services. I don't have time to develop this, but there are some very good archives in Canberra from the Colonial Sugar Refinery, CSR. And the agency relationship which they had with Carcano and Co. They were London-based sugar brokers, the largest sugar brokers in the world at one point. They acted as agents for CSR in the sale and purchase of sugar, but they also, Carcano provided an invaluable service of advice and international and information about international trends in the sugar market. Fifthly, let me focus a few moments. In fact, I don't have a watch. I'll hurry on. Let me focus on agents as distributors of goods, and the example I'm going to take is the distribution of this Watson's No. 10 Scotch whisky, case of whisky. This was blended in Dundee for the export market. Probably meant it wasn't of good quality, but there we are. Bodie Davis had a company, B. Davis Limited, and he had the sole selling agency for the distribution of No. 10, Watson's No. 10, in various parts of the world, including New South Wales. Now, Davis, from the tooth records, which I'll come to in a moment, was a flamboyant character. He ran a Rolls Royce, he gambled heavily. He was called Whistler Davis because he used to whistle to his racehorses. It was said, actually at Royal Ascot in front of the King. But in 1929, he enters this agreement with Tooth & Co. Those online in Sydney will know that as a major brewer of beer at the landmark Kent Street Brewery. The agreement was drawn up by the parties, no lawyers. Under it, Tooth assumes for a period of 10 years quote, the sole agency in New South Wales for the sale of Watson's whiskies. Tooth agrees not to assume agency for any other Scotch whisky, and you'll see there in clause 4C that Tooth undertook to push the sales of Watson's number 10. Well, anyhow, to cut a long story short, Davis is very unhappy with the volume of orders received. He complains. There's lengthy negotiations. There's then litigation. He sues in the High Court in London. The High Court says, no, it's better dealt with in New South Wales. In New South Wales Supreme Court, there's a 45-day hearing before Mr. Justice Holtz Rogers. Four King's Counsel and 2 juniors, including Victor Windia, KC, and Mr. Monaghan, KC. There's then the forensic gift for Davis, because in the course of his evidence, the managing director of Tooth says this: our whisky business is only an infinitesimal part of our business, and we are not going to cloud a good beer trade for the sake of a few gallons of whisky. What a gift. So judgment for Davis, reversed though by the full court, by a majority. There's then a discussion amongst the directors of Tooth. Are we going to go to the High Court? Are we going to go to the Privy Council? Privy Council they went to. There's then a 17-day hearing in the Privy Council in 1937. Now, before they get to the Privy Council, £50,000 has been spent on this litigation. But having reached that point, money is not going to be spared. And the leaders of the English bar are briefed for the appeal. William Green, KC, later Master of the Rolls. Gavin Simons, KC, later Lord Chancellor. Sir Stafford Cripps, KC, later Chancellor of the Exchequer. Sir William Jowett, KC, later Lord Chancellor. And various other people who became judges, so they then had to keep on briefing new council. So, anyhow, the costs mounted. The result at the end of the day was the Privy Council says, yes, Tooth was in breach. They didn't push Watson's whiskies. They'd not made sufficient efforts to sell it. The assessment of costs is still going on in the 1940s when the war begins. Davis has died. There's interesting comments amongst the directors of the Tooth. You know, when they get the brief fees for the English silks, they couldn't believe it. Anyhow, there we are. Okay, so far, let me just quickly sum up where we are. Some overall themes, and these are dealt with in the book. First of all, the commercial law is made by the practice of these brokers, agents, manufacturers, distributors, ship owners, and so on, insurance companies. It's made by the standard form contracts, which these people draw up through their associations. This is private law making. It also, the contract also builds up the institutions. I mentioned the Baltic Exchange, the London Projects Clearinghouse. This private law making enables those running these markets, these manufacturers and producers, to set their own terms. It meant that the common law and the sale of goods provisions were pushed to one side. And as the second theme is that this private law making took place without heavy involvement by lawyers. By contrast with today, lawyers were far from the centre stage. They weren't critical. Until the 20th century, lawyers were not regularly engaged in the work of formulating the rules and contracts of the London commodity markets or advising trade associations. Lawyers were more involved with the documents to carry on business rather than the carrying on of business. To carry on business, in other words, business leases, partnerships, deeds of partnership, later company formation. the third point is that drafting the standard form contracts was a practical exercise undertaken by the persons, by the traders themselves. The next point is about informal dispute settlement. That was preferred when conflict arose. Arbitration, as I've said, as the main avenue for settling disputes. It was used as a standard provision. Of course, in some cases, you did get disputes. You got this enmity between Whistler Davis on the one hand and Tooth's management on the other, leading to this extraordinary case. You also got end consumers like the pastoralists in the International Harvester case, taking a point of principle. We're not going to let these international producers who are a dud baler get away with it, but mainly informal dispute settlement. Now, I've taken Australian examples, but the backdrop of law I've been addressing is English law. And as a number of years ago, Chief Justice Alsop put it this way, that one aspect of empire in the 19th and 20th centuries was a degree of uniformity of commercial law, at least within imperial borders, enforced in the case of Britain through appeals to the Privy Council. So obviously English law was going to apply if you're going to sell your wool in London. We saw, in fact I didn't point it out, but on that earlier slide, the contract, the London Contract Association would have a standard contract which said this contract is deemed to be made in England, so English law applied. So, and the Tasmanian case is interesting because there the Tasmanian officials said, well, why can't we have Tasmanian law? And they're told by the Robert Stevenson Company as well, it's international usage to use English law. And there was the added barb. We are executing orders for all parts of the world, and in every single case the contracts are under English law. So they had to adopt English law. But even when Australian law applied, there's the overlap, of course, between the principles of English and Australian common law. The rule in Timble and Hill that colonial court should follow the decisions of the English Court of Appeal until Sir Owen Dixon's decision in 1963 in Parker and McQueen, the High Court's policy to apply English precedents at the expense of its own. In the International Harvester case, the High Court applied English precedents. In terms of statutory law, sorry, let me just put this up. In terms of statutory law, like the Sale Goods Act, the Australian states adopted almost verbatim the UK legislation, the same with the Bills of Exchange Act, when the Commonwealth adopted a law in 1909. So this is what Millard said in his Law of Personal Property in New South Wales in 1898. Speaking generally, it may be said, and said without any reflection whatever on our legislators, that there is nothing at all original in our legislation on the subject of personal property. And as Jeremy Finn has pointed out, that passage was there until at least 1965. The position changed. Many Australian writers have seen a sharp divide between the subservience of the earlier period and then the national assertion, say from the 1970s or 80s. I'm more inclined to the view that is espoused by people like Mark Lunny, that it's a much more subtle process. It's no doubt that there were historical contingencies in the Australian application of common law principles. John McKenna, QC, has shown how with the growth of law reporting, the appointment of Australian rather than English-born judges, the participation of lawyers in discussions from the different colonies in the run-up to federation, all of this changed the face of Queensland jurisprudence. As my a great friend, then Professor and later Justice Paul Finn showed 30 years ago, legislative intervention was much more absent in England, was much more evident in Australia. It was necessary to foster economic development. One small example, to go back to wool, is the Liens on Wool Act of 1847, New South Wales, enacted to overcome the common law problems of taking security over a wool crop. I first discovered wool liens in this book, which was written by the then Dean of the University of Queensland when I arrived. I couldn't understand it. What is this? But very important. And there's a very nice article by Frank Decker about wool liens. As well as legislation, there were occasional innovative common law principles. That was a theme explored as long ago as 1971 in an article which Michael and I have just confirmed appeared in an edition of the University of Queensland Law Journal, which I co-edited. An article, a very nice article by John Bennett and John Falls. They took the case of bankruptcy, and there have been articles by, for example, Professor Warren Swain on small commercial transactions. But in the absence of the same volume of shipping, commodities, insurance litigation, the bread and butter of the English commercial court, there wasn't the same justification here for the adamantine hardness in Australian contract law. And thus, to go back again to wool, unconscionability, the doctrine of unconscionability had a freer reign. And it began, as I say, with wool in Bromley and Ryan, involving a grazier who ran sheep at Bogabilla in northern New South Wales, selling his property at an undervalue. And as the lawyers amongst you will know, the High Court set that contract aside because the grazier was vulnerable through alcohol and age. And with that seed, you got the flowering of the English doctrine of unconscionability, potent for commercial transactions through both common law and statute, the like of which we've never seen in England. And whether this was matched by other judicial innovations through, for example, commercial custom, which was used a lot in England and Wales, Bruce Kershaw has suggested the same might happen here. That's a matter for inquiry. And then, of course, institutional developments. New South Wales declined, of course, to accept the judicature system, retained the separation of common law and equity. That recently culminated in assigning matters previously in the commercial division of the New South Wales Supreme Court to the new commercial list administered by the equity division. Lord Atkinson must be turning in his grave. But there's an exciting story to be told here about the history of common law principles applying in commercial transactions in the economic and social context of Australia. And it's a story which, as I've suggested, can be told because there are business archives available around the country. If it's a story that needs to be told in terms of colonialism, race and gender, then all to the better. But it's an exciting story, I would say, that can be told. So thank you very much for the invitation to give the lecture, and thank you very much for your attention.
Before I thank our speaker, I perhaps should say something in my own self-defence. Ross and I didn't go to Sandgate last night to eat fish and chips. We went there to see the Atkinson monument. And as we were driving along the foreshore at Sandgate, Ross spotted a fish and chip shop that was had family memories. So Sandgate has been the playground of Lord Atkinson as a child, and Ross as a young person as well. In fact, as we went past the Shorncliffe Golf Club, Ross was recalling playing golf with his father there, and what would have been a promising golf career had to be parked at the end of high school in order to concentrate on studies. Well, Australia's produced many, many fine golfers, but we're rather pleased, Ross, that you turned your back on golf. You would have just been one of a number of very good Australian golf players. So we've had plenty of good Australian golf players, but very few scholars and jurists of your standing. The book is in the Law and Context series, and is a great addition to that tradition of academic excellence. The Law and Context means something to many of us. In the lecture tonight and in the book, it shows our speaker's deep knowledge of history, his understanding of commerce and economics, and his mastery of legal principle. Because Ross is flying back to the United Kingdom shortly, we didn't get him a big book, we got him a little book so that you didn't go overweight when you fly. It's a small but a lovely book, which we hope you'll enjoy. It will, we think, engage your knowledge and interest in law and history. So with that token of our appreciation, could you join me in once again thanking our speaker, Professor Sir Ross Cranston.